The court that never said yes. Picture this. It's California, the state with the toughest gun laws in America. For decades, politicians kept adding more restrictions. 1 gun per month, waiting periods, background checks stacked on top of background checks. And every time someone challenged those laws in court, the Ninth Circuit was there with the same answer. No, denied. Rights don't apply here. For 134 years, gun owners called it the graveyard of the Second Amendment. Not once in its history did the Ninth Circuit ever strike down a gun control law on Second Amendment grounds. Not once, until now. On August 14th, 2025, the impossible happened. The Ninth Circuit didn't just rule for gun owners, it issued something far stronger, a final mandate, a binding order that ended California's 1 in 30 law and could not be appealed away, overturned, or ignored. That moment marked the first time in American history that the most hostile court to gun rights became the very stage for one of the biggest victories the Second Amendment has ever seen. And if you think California is about to take this lying down, think again. New bills are already moving through Sacramento, proving that while gun owners may have won a historic battle, the war for rights is far from over. So tonight, we're diving into why this mandate matters, what it means for your rights, and how this single case might reshape the fight for the Second Amendment in every corner of America. And if this is your first time here, welcome to Firearms Law Advisor, the channel where we cut through the noise and bring you the real, fact-driven breakdowns of the legal battles that affect your rights. No spin, no hype, just the truth you need to know. If you care about staying informed on how courts, lawmakers, and agencies are shaping the future of the Second Amendment, make sure you subscribe right now. Chapter 1. A shocking first in 134 years. Imagine the year is 1891. The Ninth Circuit Court of Appeals is created to handle the exploding caseload of a rapidly growing western United States. From the start, this court became infamous for siding with government restrictions over individual freedoms. Fast forward through world wars, civil rights battles, and cultural revolutions, and one thing has remained constant. In 134 years of history, the Ninth Circuit had never, not once, issued a final judgment striking down a gun law under the Second Amendment. That's right. Countless times, 3-judge panels within the Ninth Circuit ruled in favor of gun rights, but nearly every single time, those victories were snatched away when the full court stepped in to reverse them. If you were a gun owner in California, Hawaii, Oregon, or Washington, the Ninth Circuit was like a wall that always held firm against the Second Amendment, until now. On August 14th, 2025, something historic happened. The Ninth Circuit issued its very first mandate, affirming a Second Amendment victory, Nwin vs. Bonta. For the first time in over a century, this court said no to California's gun restrictions in a way that cannot be undone. A door that had always been slammed shut was suddenly cracked open, and gun owners across the nation took notice. Chapter 2. The Case of Nwin vs. Bonta. At the heart of this breakthrough is a simple but powerful question. Can a state ration constitutional rights? California has long believed the answer is yes. For years, the state enforced its 1 gun a month law. Under this rule, even if you passed background checks, followed every regulation, and obeyed every law, you were only allowed to purchase 1 firearm every 30 days. The case, Nwin vs. Bonta, challenged this restriction head-on. Plaintiffs argued that the law treated the Second Amendment not as a right, but as a privilege that the government could ration like gasoline during wartime or sugar during the Great Depression. They pointed to the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, 2022, which reaffirmed that gun laws must align with the nation's historical tradition. And nowhere in America's founding history was there a tradition of rationing firearms to law-abiding citizens. On June 20th, 2025, a 3-judge panel of the Ninth Circuit agreed. They struck down California's 1 gun a month law as unconstitutional, but seasoned observers held their breath because everyone knew what usually came next, an en banc reversal, where the larger panel of Ninth Circuit judges would swoop in and erase the decision. But on August 14th, instead of reversal, the Ninth Circuit issued a mandate, the final binding order that cemented the ruling into law. No rehearing, no delay, no appeal. The case was closed. Chapter 3. Why this has never happened before. To understand why this moment is so monumental, you need to know the Ninth Circuit's track record. Time and time again, California gun laws have been challenged, and time again, the Ninth Circuit has stepped in to protect them. Take the case of Duncan versus Bonta, where a federal judge struck down California's ban on magazines holding more than 10 rounds. A 3-judge panel agreed and ruled in favor of gun owners. But what happened next? The Ninth Circuit took the case en banc and promptly reinstated the magazine ban. Or look at Miller versus Bonta, the case challenging California's so-called assault weapon ban. A district judge declared the ban unconstitutional, comparing AR-15 rifles to Swiss Army knives for their versatility and common use. But the Ninth Circuit immediately put that ruling on ice, ensuring the ban stayed in place. For decades, this was the pattern. Small victories followed by crushing reversals, which is why the August mandate in Nwin versus Bonta shocked everyone. For the very first time, a Second Amendment win inside the Ninth Circuit survived. The most anti-gun court in America had allowed a pro-gun decision to stand. Chapter 4. California's Relentless Counterpunch, AB 1078. But if you think California is taking this defeat quietly, think again. The ink on the mandate wasn't even dry before lawmakers in Sacramento were already pushing their next restriction. Assembly Bill 1078. This bill would replace the 1 gun a month rule with a slightly looser 3 guns a month rule. On paper, it looks like a concession. In reality, it's California's way of thumbing its nose at the court's ruling. The logic is simple. If the judges say 1 per month is unconstitutional, then maybe 3 per month will pass muster. But here's the problem. The Ninth Circuit's panel already made clear in its decision that you cannot ration rights. Whether it's 1 gun, 3 guns, or 10 guns, the principle is the same. The Constitution doesn't say you can exercise your rights some of the time. AB 1078 already passed the Assembly and is moving quickly through the state Senate. Supporters argue it's a reasonable compromise, but gun rights advocates call it a blatant attempt to sidestep the mandate. California has a long history of playing this game. When one law gets struck down, they tweak the language and pass another, forcing endless rounds of litigation. So while gun owners celebrate the Nwin versus Bonta victory, they know the fight is far from over. Chapter 5. You can't ration rights, what the court said. Perhaps the most powerful part of the Ninth Circuit's ruling is the language itself. The panel didn't just strike down the law, they explained why it was fundamentally incompatible with constitutional freedoms. The judges wrote that rights are not privileges to be rationed out by the state. They drew comparisons to other rights. Imagine if California passed a law saying you could only attend church once a month, or that you could only publish 1 article every 30 days, or that you could only vote once every 3 elections. Every American would immediately recognize those restrictions as outrageous and unconstitutional. By the same logic, limiting law-abiding citizens to 1 gun per month treats the Second Amendment as second class. The court made clear that such rationing has no place in American law. This reasoning goes beyond just California. It sends a message to every state considering time-based restrictions. You can't pick and choose how often citizens get to exercise a constitutional right. The government doesn't get to hand out liberty with a stopwatch. Chapter 6. The ripple effect beyond California. This isn't just about one state. When the Ninth Circuit issues a mandate, every state in its jurisdiction feels the aftershock. We're talking Alaska, Arizona, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, all now have a brand new precedent on the books. The ruling doesn't instantly erase every restrictive law, but it sets a clear marker. Rationing rights, whether it's 1 gun a month or 3, is unconstitutional. Legislators in other states will now think twice before pushing similar limits. Courts will be forced to ask, if the Ninth Circuit calls it a violation of the Second Amendment, how can we justify it? Chapter 7. California's Counterattack. If you know anything about California politics, you know they don't surrender. Even as this mandate landed, lawmakers were already preparing AB 1078, a bill that tries to limit purchases to 3 guns every 30 days. Think about that for a moment. The Ninth Circuit just declared rationing unconstitutional, and Sacramento's response was, fine, let's ration differently. This isn't just resistance, it's defiance. It's proof that California sees the Second Amendment not as a guarantee, but as a loophole they're constantly trying to plug. And make no mistake, if they succeed, you can bet other states will try the same workaround. Chapter 8. Why the Mandate is Bulletproof. Here's the part that makes this so historic. A mandate is the court's final word. It isn't a temporary win from a 3-judge panel. It isn't a decision waiting to be reversed by an en banc review. It's locked, it's binding, and it's enforceable. California cannot appeal this further. The Ninth Circuit itself cannot pull it back. The U.S. Supreme Court doesn't need to get involved. The law is dead. For gun owners who have lived through decades of whiplash, one day celebrating a panel victory, the next day watching it vanish, this mandate is the first solid ground they've had in over a century. Chapter 9. The Political Earthquake. Don't underestimate the optics here. For decades, anti-gun advocates pointed to the Ninth Circuit as their firewall. It was the court they could always count on. That firewall just cracked. This case will now be used by attorneys in lawsuits across the country. Anytime a state tries rationing, lawyers will cite Nwin versus Bonta and this mandate. Every courtroom battle moving forward will have this ruling hanging over it, and politically, this changes the map. Legislators in purple states, places like Nevada and Arizona, now face a new question. Do we really want to back laws that the Ninth Circuit itself has declared unconstitutional? Chapter 10. The next battles ahead. Victories like this are rare, but they are not the end. The fight shifts now to defending this precedent and stopping new laws like AB 1078 before they gain traction. California may have lost this round, but their machine keeps moving. Expect to see new strategies, limits dressed up as safety measures, registration schemes, even digital surveillance of purchases. Each one will test whether this mandate has teeth or whether California can simply dance around it. And that's why this isn't just a win for California gun owners. It's a warning to every American who values freedom. Vigilance is the price of liberty. A century in the making. For 134 years, the Ninth Circuit never sided with the Second Amendment. Not once. Gun owners stopped hoping. Lawyers stopped trying. The court was a dead end. But now, the dead end just became the starting line. The mandate in Nwin versus Bonta will be remembered as the moment the Ninth Circuit cracked open the door it had kept shut for generations. A court that was once the graveyard of the Second Amendment is now the birthplace of its rebirth. History isn't written by one case, but this case just rewrote history. The question is, will gun owners across America rise to defend this victory, or will they let California and other states bury it under new restrictions? That answer, my friends, isn't up to the courts. It's up to us. So here's what I want you to do right now. Share this video with your community. People need to know that this mandate just changed the game. Drop a comment below. Does this ruling finally make you feel like the courts are waking up? Or do you think states like California will keep finding new ways to push back? And most importantly, subscribe to Firearms Law Advisor for more real, fact-driven breakdowns of the legal battles shaping your Second Amendment rights. Stay sharp, stay legal, and above all, stay free. We'll see you in the next one.